Hello again. We had a great lunch and we're back now. And I'm going to introduce our moderator, Mr. Lino Mendiola, who is a business practitioner with the Austin office of the law firm Andrews & Kurth, who is always very supportive of our organization. So we welcome him to moderate this panel. And thank you.
Thank you, everyone. My name is Lino Mendiola, and as Javi mentioned, I'm going to moderate this panel on Fisher v. Texas. Fisher v. Texas was recently granted writ of certiorari by the U.S. Supreme Court. This case has the potential to outlaw race-conscious admission practices at public colleges and universities. We have a distinguished panel here of commentators comprised of former dean of the UT Law School, a litigator with MABA-TX, and the great and inimitable Norman Cantu, who I'll talk a little bit more about later. The format for today's discussion will be as follows. First, I'll provide a brief background on the legal issues involved in Fisher v. Texas, and then I'll introduce our distinguished panelists, who will then each take a few minutes to offer their thoughts and comments on Fisher v. Texas. We can expect somewhere between 5 and 7 minutes per panelist. After each panelist has had an opportunity to share their thoughts, we'll have a free-flowing discussion, I hope, and an opportunity for questions and answers. So before I introduce our guests, I'd like to take a brief moment to offer a bit of context for our discussion. The facts of Fisher v. Texas can be found online. I'm not going to review those here. I'll focus instead in our short time on issues of law. It's undisputed that in the comparatively small number of admission slots not filled by the top 10% rule, UT examines the applicant's personal circumstances, including extracurricular activities, work history, leadership, community involvement, and race. It is that consideration of race and ethnicity that the Supreme Court will examine in order to determine whether UT's admission criteria violate the Constitution. As most of you in this room know, at least I hope you know, a government actor that considers race in the conferring of a benefit or a burden receives the highest scrutiny, the highest review, and the highest level of examination known as strict scrutiny. Strict scrutiny analysis is based on the Equal Protection Clause of the 14th Amendment. That provision says that no state shall deny to any person within its jurisdiction the equal protection of the laws. The argument is that in considering race as one factor among many factors in the admissions process, a public university is denying an equal protection of the laws to individuals who are of different races. Yet Justice O'Connor has reminded us, and the Supreme Court reiterated in the Grutter v. Bollinger case, that strict scrutiny should not be strict in theory, but fatal in fact. That means the U.S. Supreme Court has determined a small place where race can be considered without violating the Equal Protection Clause. So the question in this case is whether the University of Texas properly falls within that small space created by the Supreme Court. UT maintains that its actions are constitutional because it has made an, quote, educational judgment that diversity is essential to its educational mission, just as the University of Michigan Law School did in the Grutter case. And diversity in the context of higher education is therefore a compelling governmental interest. The case is now before the Supreme Court of the United States, which will decide whether institutions like UT can lawfully continue to consider race as one factor among many in its admissions process in order to create diversity among its student body. So with that background, I'd like to introduce our guests. First, our first guest is Mr. David Hinojosa. He is a regional counsel for MABA-TX. He's a proud graduate of Edgewood High School in San Antonio, and if any of you know the history of school finance cases in Texas, you should know a little bit about Edgewood High School. Interestingly, he was an air traffic controller in the Air Force, so he should probably be up here doing the moderating. He's a graduate of UT Law School in 2000 and has spent a long time at MABA-TX and is now devoting his career to impact litigation that will impact the civil rights of Latinos and others in our state and everywhere else. Next on our panel is the former Dean of the UT Law School, Dean Larry Sager. Dean Sager, I think as most of you probably know, is a renowned scholar of constitutional law, specialist in the First Amendment and the other amendments of the Constitution. He is, prior to coming to UT, he was the Robert McKay Professor of Law at New York University. And his publications are too many for me to begin listing. It would take up all of our time. So I'm looking very forward, though, to hearing the Dean's comments. We also have with us Norma Cantu. She is a professor with the joint appointment at both UT Law School and the UT School of Education. For 8 years, she served as the Assistant Secretary of Education for Civil Rights in the Clinton administration. There, she oversaw a staff of approximately 850 employees, including employees with oversight over governmental policy for civil rights and American education. She became known during that time as the nation's chief civil rights enforcer in the education arena. It's not bad for a girl from the RGV. You all know what that is, RGV? Rio Grande Valley? Before her work in the Clinton administration, Professor Cantu worked for 14 years as regional counsel and education director for MABA-TX. She's a proud graduate of UT Pan Am at the age of 19, actually. And then she enrolled in Harvard Law School, where she graduated at the age of 22. But of all of her accomplishments, here's something that you may not know about Professor Cantu. She is a 2-time finisher of the Marine Corps Marathon and also a proud finisher of our own Austin Motorola Marathon. Twice. Very good. Ladies and gentlemen, let's start with Professor Cantu to hear your comments.
I'm allowed 30 seconds of fluff before we actually get into CLE. The first marathon was because I saw a sign in the Lane Bryant store, which, you have to be like a 2X or 3X. They said, we will train anyone to finish a marathon, and they meant it. So education opens the door for miracles. The other thing, the value of CLE is that something totally unexpected can happen. In this same building 2 days ago, the State Bar of Texas School Law section presented on the use of assistive animals for students with disabilities, and the speaker brought in 2 miniature horses which reach you about the knee, and they were housebroken, adorable, and walked among the lawyers. Best CLE ever. Okay, back in dog and pony show. Back in 1981, I became the attorney for MABA, in representing Mexican-American students, organizations, as well as professional organizations, in a suit to try to get the Office for Civil Rights in the Department of Education to get off their butt and either conclude their investigation of the exclusion of Hispanics from higher education or conclude their negotiations. They were claiming they were doing both but had completed neither. Because of my role, and it's all your fault, I was recused for 8 years from the Hopwood case, so none of my presentation goes to Hopwood. What I want to talk about for 3.5 minutes is what happens when you're in complex litigation and you've been involved in one suit for more than 20 years. Since I have been involved in higher education access by Hispanics for more than 20 years, I'll tell you, when you get 2 or 3 decades into a suit, you start hearing very unique questions that are taken out of context. And it's really important when you hear about a case like this to look at the context. The background to this case is that the facts have changed over 20 years. That, it really was about Mexicans who were many generations in the United States when MABA first brought this issue of access to higher education. And what the Fifth Circuit is now looking at is a situation where we have changed our definitions of what minority means. And the Office of Management and Budget now allows students, adults, to click several boxes. They can be African American and Latino, they can be multi-race today. So taking that into context. Secondly, what the state defendants, the state actors who were first brought into court objected to the use of any numbers, any kinds of categories where you counted percentages. And my direct experience in the Keys versus Denver case was that the school board challenged every case by saying the plaintiff attorneys want a specific number. They want to tell us how many Hispanics, Mexican Americans to enroll in schools. After 20 years in the case, the school board voted that they should be released from the case because they had achieved a certain percentage and a certain number. Both folk are wrong. You cannot resolve a case like this based on just a single set of numbers. We are not about quotas in any of these multi-decade cases. But it is a challenge to put the context behind that the attorneys representing Ms. Fisher are using numbers, using the percentages to try to isolate their legal argument from the facts in the case. The complexity of the case also means that the court is turning to the state actors for the context, for the expertise, for the understanding of what do these legal arguments mean when applied to the facts at hand. And those of you remember from law school where they talked about Supreme Court deference to judicial agents, to administrative agencies, and should that deference be based on how complex the cases are, or what level of expertise those federal agencies had, or to what degree those agencies gathered information and allowed for a lot of notice and comment. In this particular case, the issue of deference to the state actors has all of that in it. The state of Texas has collected data. The state of Texas has had state legislative hearings where people have had opportunities to comment about this issue of access for Hispanics. And they do have expertise that is unique and beyond what someone you walk into the street would know. But more than that, and this is an important layer, and you'll hear Dean Sager talk about it, more than that, the university has a First Amendment cloak to wear. So the University of Texas is wearing many hats. By the way, the expression I love is, the more hats you wear, the more shoes you can buy. So the state of Texas is wearing the hats of delivering the education, providing expertise on the state policy that is enacted with regards to the provision of education, and understanding the complexity of the data related. But they're also wearing the constitutional cloak of protecting the First Amendment rights of faculty. And now that I'm a member of faculty, now I get it. You need to have that First Amendment academic freedom in order to create places where people can learn. It's like what happens in Vegas stays in Vegas. What happens in my classroom stays in my classroom. That academic freedom is incredibly important. And so this Fisher case is more than a threat to affirmative action. Let me take it beyond minorities. When folk are trying to defend the university's decision to create as diverse a classroom as possible, they're also standing up to defend First Amendment academic freedom for educators. So it's a big case. It's an important case. As I was recused from Hopwood, Justice Kagan is recused from participating in this important appeal to the Supreme Court. And I don't even want to predict, what the outcome will be. But you're going to hear two speakers who will do a better job. So thank you. And no dog and pony.
We at MALDEF, we attempted to intervene into the Fisher case right when it was filed on behalf of Longhorn, LULAC, and other Latino students who were in high school and wished to attend the University of Texas but might not have made it into their top 10%. And much has been made about the top 10%. Frankly, I'm not very happy with the university's position on the top 10% where they want to cap it, because if kids work hard enough to be in the top 10%, then they're probably good enough to go at least to one of the flagships here in the University of Texas. There's incredible inequities still across our schools, so the opportunities, because people want to say, well, like for instance, Miss Fisher. Miss Fisher did not get into UT, not because of her race, as much as it was that she did not make it into the top 10%. And the reason why I say that is because when you look at the factors that UT considers, either you're the top 10%, and that's actually capped now at 75%, or it's what was defined during the case as a factor of a factor of a factor. So all the way down there, if you look at AI, that stands for academic index, which, who's to say exactly how great of a predictor they are in student performance in colleges. So those are some factors. Now the other index you have is the personal achievement index, and that accounts for 50%. There's no exact score, it's more or less taken down on a grid, some kind of matrix. So then when you look at those, you look at a couple of essays, then among that you look at other factors, and among the special circumstances, race is just one of those factors. There's no evidence in the case that her race kept her out, because there were other minorities, believe it or not, who had higher SAT scores but weren't admitted. So how could they not be admitted because of their race, but yet she was not admitted because of her race? So that's one particular factor. And when we look at this, when you say, well, a couple of the issues that, well, let me get back to our intervention first. When we attempted to intervene, UT did not oppose our intervention. We, along with the Legal Defense Fund, the NAACP Legal Defense Fund, attempted to intervene into the case because we just didn't trust UT to make the arguments, because aside from making the compelling interest argument as far as diversity is concerned and what benefits accrue from diversity, you can also, you may be able to use race if you can show why you might not have diversity. So the way that UT demonstrated, and I think Dean Sager is going to get into a little bit more, is through a survey and a couple of other things that they did. But they didn't necessarily speak of some of the acts of discrimination that have taken place here at the University of Texas against Latinos, against African Americans. And when you look at it in that context, that's an important piece of evidence that's now missing in the record. Because now what's being argued strictly, and UT, to its credit, is not going to come forward and say, oh yeah, well, we needed to do this because frankly, we still have race issues on our campuses, right? They're not going to want to say that, but we will want them to say that because we had people lined up to talk about these issues. But we didn't get granted intervention, but we did submit an amicus brief both in support of UT's motion to dismiss the plaintiff's case, and then again at the Fifth Circuit. Once the lower court, the district court, affirmed UT's use of race, said that it was very limited, just like Grutter. They said, if Grutter is right, the plaintiffs are wrong, and that's what he ruled. That's why he dismissed the case. He found that, yes, there was a compelling governmental interest, which no one really disputed here. It was whether or not UT's means of achieving that governmental interest were narrowly tailored. And so when you look at the narrow tailoring and you look at Grutter, they're talking about individualized, holistic consideration of applicants. And that's both should satisfy Justice O'Connor's opinion, as well as even Justice Kennedy's dissenting opinion in Grutter. But now the case has been appealed up to the U.S. Supreme Court, and we'll end up filing a brief there as well. And our biggest interest, of course, is to defend diversity admissions plans, that use race as one factor, certainly not a factor. There is no quota here used at UT, unlike what happened in Michigan, which was approved by the Supreme Court. They don't even do daily reports. At University of Michigan, something that Justice Kennedy and others found disturbing was they were getting daily reports of how many minorities do we have, how many are we enrolling, what percentage are they, and they would range from like 12% up to 20%. And to be honest, to me, even a civil rights litigator, that's pretty troubling. You know, because yes, you should not use race except in very limited circumstances. And when you have those daily reports coming in and you can continue to reflect back to them, especially towards the end of your admissions plan, you know, it is a little bit troubling. Now, you take into the context the First Amendment right that universities should have, you know, and that's why it's not thrown out the door, so to speak. So, but now that we're at the Supreme Court, you know, the two issues, well, the central issue is whether Grutter permits UT's use of race, right? Whether or not they've used it. Some people have argued that, well, you know, this case is going to throw out the use of race in university admissions plans. That's a flat lie. That's just for the headlines. That's just for the blogs. That's for people to have stuff to write and people to read on the internet, frankly. If you read Justice Kennedy's dissenting opinion in Grutter, if you read Justice Kennedy's concurring opinion, which basically is similar to the Powell opinion in the Obaki case, because you know you have the 4 justices and then you have Justice Kennedy. He says, yes, diversity is a compelling interest, both for K-12 and for university admissions. Universities is a slight different issue, but the main issue that they're attacking right now is unwarranted deference to UT. So, and if you look at the opinion, because when that opinion came out from the 5th Circuit, you know, there was Judge Higginbotham, Judge Garza had signed off on it, and I forgot who the other judge was. Not exactly your civil rights friendly judges on the 5th Circuit. And when you look at that opinion, you're like, wow, that's a pretty strong opinion. And, you know, in retrospect, it's probably too strong. Because, you know, what they're basically saying is, well, you know what? Grutter said we had to let him do it, so we're going to let him do it. Grutter said they had substantial deference, we're going to give them that deference. They gave deference both to the compelling interest, of course, you know, which they should, but also reading in substantial deference to the narrow tailoring piece. I don't think they necessarily had to do that. I'm not saying that they did that purposefully, but if you read Justice Kennedy's dissenting opinion in Grutter, it looks a lot like that. And, you know, some of the concerns that they have. And so now when you read, you know, the petition for cert filed by the plaintiffs, it reads a lot like that. Because regardless if Justice Kagan recuses herself, it's still Kennedy's court. Because Justice Kagan, assuming that they were to rule, as many scholars would suspect, it would be 4-4, and then you have Kennedy. Where's he going to be at, right? I think Kennedy's probably one of the most powerful men in America right now. But, you know, now that you lose Kagan, who is it still there? Kennedy, right? Because of 4-4, the tie goes to the winner, and the winner, of course, is UT. So, but they're also, you know, not only are they disputing the substantial deference to UT, but they're also saying that, you know, through that they've abandoned strict scrutiny. You know, by tweaking this issue, allowing substantial deference, you're abandoning the strict scrutiny that you're supposed to have, and they cite a whole bunch of employment cases that, lo and behold, Kennedy had also cited in his dissent in Grutter. But, of course, Grutter controls now. So Kennedy's not going to throw Grutter out the door. Of course not. You know, the worst that could happen here probably is that they limit it even further. Because Kennedy limited, in the Seattle versus Picks case, he had limited affirmative action in K-12. He still identified a number of different ways that schools would be able to use race, either through race-conscious plans, like the top 10% has been described as, even though it's really a race-neutral plan. So, you know, that's one of the issues. But another of the issues is what kind of impact does the use of race at UT have? And I'm going to just speak real briefly of this, but it's a very, very questionable approach. When you look at the percentage of Latino and African American at UT, Hopwood was decided in 1996. 1997, the top 10% plan comes in to play, and the top 10% has benefited Latino students substantially over the years. It's opened doors, and of course not just to Latinos, because if it's just going to be for Latinos, I can guarantee you the Texas legislature is not going to pass that kind of law. But nevertheless, as the years go through, and I think it was around 2004, 2005 when UT decided to use race. And the numbers look like they went up because of that. But then when you look at the non-top 10% students, so students where you're supposed to be able to use race versus the top 10%, which is race neutral, almost 2 out of 3 whites, or if you look at the total population of non-top 10%, almost, well, 3 out of 5 are white. 1 out of 9 are Latino. 1 out of every 25 are African American. So when UT's allowed to use race, it doesn't look like they're doing a very good job of it. That was one of the criticisms that Kennedy had of the Seattle plan and the Louisville plan was, you know, what kind of impact were these plans actually having? Even when you jump down to 2010 and you look at the non-top 10%, that's kind of wrong. It says with race conscious, but that's not necessarily true. That's with race. And you look at the total freshman admit, so you're looking at all the kids who got in, whether it's the top 10% or non-top 10%. Well, 1 out of 3 whites are admitted outside of the top 10% plan. 1 out of 9 Latinos are admitted. So when you can use race, I'm not exactly sure they're doing a very good job of it. So, you know, those are issues that UT is going to have to confront. They've kind of pushed them to the side. They've had a relatively easy path right now, but you know, these are issues that we're going to have to confront on appeal. You know, but at the bottom line, we're there. We're especially there because we want to protect the use of race by universities. We have, you know, publications on our website at MABA-TX on permissible uses of race and so forth. But I'll leave it at that and turn it over to Dean Sager. Thank you very much.
Good afternoon, everybody. My advanced billing by my colleagues on this panel overstates what I can and will do. I'm actually going to speak relatively generally, a little bit about theory and a little bit about practice, and sort of in between a bit about the case of Fisher itself and how we should feel about it. About theory, I was struck by the suggestion that race-conscious admission is subject to the highest scrutiny available under our Constitution. I actually think that isn't true, but it isn't true because of an odd, failed doctrinal statement and syllogism. It ought to be true in the following sense. The court has insisted, wrongfully I think, but the court has insisted that racial conscious admission is subject to strict scrutiny, the compelling state interest test. And strict scrutiny, the compelling state interest test, is indeed the highest form of scrutiny that is available in our system. But somehow the strict scrutiny to which racial consciousness is subject, at least under Justice O'Connor and the court that she was able to carry on this, it's strict scrutiny with an asterisk. The test is named the same test, but it's simply a softer, more flexible test. So if you read her opinion in Grutter and in elsewhere, when she talks of these questions, she allows variables into the equation that would never be allowed into true strict scrutiny. So the court and she always engaged in this kind of, this kind of benevolent charade of insisting on strict scrutiny but bending it slightly. And an instance of that, take Texas's top 10 plan. If we were really in the world of strict scrutiny a la race, then Texas's top 10% plan would have to be justified as racial conscious legislation, right? What was its purpose? Its purpose was to increase racial diversity. That's pretty much undeniable that that was a major purpose. What was its effect? Well, it didn't do a very good job, but it did a medium job. Or what? If we were talking about a facially neutral plan that was intended to operate to the disadvantage of racial minorities and succeeded to this extent, we would have thrown that plan out. So we've always had some weird, unstable view of racial consciousness. And it's high scrutiny, it's constrained. We're going to end it in 25 years perhaps because we may not need it any longer. There needs to be a justification. But it's never really been old-fashioned strict scrutiny, and a good thing, or we wouldn't have Grutter and the small window that we have. I just want to sort of make that observation. Second observation, talking about Fisher, two things were true in Fisher, and they both could go away at the Supreme Court, unfortunately. One thing is the formal structure of that case is a plaintiff who said, I don't challenge Grutter, and I don't challenge and I don't dispute that UT is operating within the ambit of Grutter, but for one circumstance. Namely, because UT has in effect already the top 10% plan, they don't have the justification for Grutter that another school that did not have such a leg up on diversity would have. So the plaintiff's case was in some ways narrow and vulnerable. And it depended on a showing that the top 10% plan had effectuated diversity, so that Grutter was no longer apt. And as we've just been shown, that's a fairly weak read on which to lean. So in a certain way, the case was positioned in a poor way from the standpoint of those attacking race consciousness. The other thing I want to say from personal experience, because a number of us at the law school met and talked with James Ho, the Solicitor General, who took this case, is whatever one might have worried about the Solicitor General's office and their commitment to this case, James Ho's commitment was total, and he was an extraordinarily competent lawyer who led a very strong defense of the school's position. Now, the question is, are both of those things going to be in place at the Supreme Court of the United States? The first one, that the structure of the case is so vulnerable, the Supreme Court's famously able to sort of overlook the technicalities when it wants to. And there are famous cases where if you read the Supreme Court decision, you wouldn't believe that the actual structure or record was there. The justices make the world that they decide. So the justices may not be nearly as faithful to the structure of this case as were Judge Sam Sparks and the Fifth Circuit. And say what you will about the judges on the Fifth Circuit, including Patrick Higginbotham, these were people whose ultimate commitments to justice in higher education and justice in higher education were very, very high. So I'm worried that the spectacular success of this case at trial and at the Fifth Circuit might not hold in the Supreme Court. Certainly, past performance isn't a comfortable prediction of the future. On the other hand, the court knowingly has taken a case where the structure in many ways favors what the university is doing, and that might be a very good harbinger of what's afoot. But I'm uneasy for the reason I've described. Now, the last thing I want to talk about is an idea that's important to Grutter, and in a way important to litigation of on behalf of race consciousness admissions policy. And that's the idea of critical mass. Now, critical mass does not have to be the measure of what a school is entitled to aim at, but you do need some measure. If the claim, we don't want quotas, but we have to have a conceptual metric, right? And if the claim is, for example, that a school is acting in remediation for past wrongs, you have to have some understanding of how far can the school go in the name of doing that. You need a conceptual metric. If the claim is equity in the society requires a certain degree of racial consciousness, something which obviously moved Justice O'Connor with the generals, with the generals brief, for example, then you still have to have some idea of what's the conceptual metric that's going to guide you to know when you have reached the point that you were aiming at. What's the target? Not numerically, but conceptually. And if your notion is you need to secure diversity in your university, and that implies in part on behalf of the people you are admitting a critical mass, then critical mass is playing that role of metric. Now, I actually, when I thought about this morning and thinking about what I might talk about, I came to realize critical mass is in some ways not offensive, but a kind of an off-putting notion, right? It seems to be taken from physics, not from sort of human beings, but the concept is a humanistic one. And the language could be far better, and the metaphor far better. The metaphor aims at the idea that if we want to enlarge our academic community to include, for example, the Hispanic community, we ought to do so in a way and at the numbers that there is a viable sense of culture, belonging, friendship, excellence, and so on. It's a very complex humanistic notion about a viable place for persons who are now going to, in a powerful way, populate our community. Now, I just want to observe the importance of that, and then I want to say, you might think that the notion of critical mass, apart from being a bad term, is just a kind of a placeholder. I want to suggest, based on a very happy circumstance at the University of Texas School of Law, that that isn't true at all, because at the University of Texas School of Law, through a tremendous amount of effort, some on the part of the school, many on the part of the people in this room and our students, and Chilsa in particular, we've reached the point of a critical mass. There is a genuinely viable, thriving, achieving community of Hispanic students. And the difference between that and some add-on to a community is profound. The numbers, by the way, are interesting. The law school now enrolls about 60 students in every first-year course. There are somewhere between 180 to 200 law students at UT are Hispanic. A shocking fact, not about us, but the rest of the world, is that's about 10% of all the Hispanic students enrolling in America. There's something like 220 law schools in America. Some of them are good. Some of them are, in barber shops or, correspondence courses. You take all 210, there were 600 and change Hispanics enrolling in law school this year, and 60 of those are at the University of Texas. And that's spectacular. And it didn't come easy. It includes a great deal of recruitment, a great deal of hard work on behalf of the people we've recruited, a great deal of hard work on behalf of many of the people in this room. But it's an achievable goal that a community really becomes an attractive and important part of the identity of an institution and viable on its own footing. Not accidentally, given the folks in this room, 2 boards of the Law Review ago, the editor-in-chief of the Law Review was Hispanic, the managing editor of the law review was Hispanic. Because they had so much time on their hands, they went off and won the National Mexican American Bar Association's moot court as best advocates and brief writers in the midst of all this. As you in this room know better than almost anyone else, CHILSA is the most robust and important student organization on campus, in my judgment. That's the world that one ought to achieve when one sets out on the ventures that we're talking about. So there is something there. It's not a placeholder, but it's not present in most academic institutions at most times as regard to most groups that aren't the majority groups there. So that's both to celebrate what's happened at the law school, but to suggest that this undergirding concept of critical mass is a meaningful concept. So that's all I want to talk about, except to answer questions, and thank you very much.
Thank you very much to this panel of distinguished commentators. There is a degree of optimism on this panel that I'm somewhat surprised at regarding this case, and may just be that my years of practice have jaded me somewhat in my expectations of what to expect from the U.S. Supreme Court. So I'm very pleased, and you've helped me in my optimistic outlook. So we have about 2 minutes left. I'd like to open it up to questions and answers. And the panelists have a microphone here. I think the room is small enough that we can probably ask questions without a microphone, but please do stand up and project your voice. Yes?
Maybe before getting into the nuts and bolts of Fisher, I'm wondering if the panelists think that there's maybe an agenda on the court to grant cert in this case. The court has taken on the Arizona immigration case. They've taken on the healthcare case. Now they've taken on an affirmative action case. Prop 8 is on the horizon in California as well. So I'm just curious if the panel has any thoughts on that.
Okay, and just as you consider answering that question, I'd like you to comment on the comment that Justice Roberts has made in the past in the Seattle case, that the best way to achieve a colorblind society is to not consider race at all.
The same question was asked of Judge Posner at the National Education Law Association meeting as to what would the Supreme Court do
with these cases, in particular, if they, at that time, if they were to take Fisher. And his perspective is that the court is bothered more by the K-12 situation where in the Seattle case, children were given constitutional protections, and he thinks the court wants to use this as a vehicle to carve back on K-12 rights, constitutional rights of students. In his dicta in the speech, off the record, not published, so I'm just paraphrasing, he says too many parents and too many children are whining and bringing too much litigation that is not critical and fundamental. And so his prediction is that there is a political angle behind some of these grants of cert, not an intent to rewrite existing case law.
I want to begin by saying maybe I was being too delicate in certain respects early in my remarks, but I'm not especially optimistic. I'm not deeply pessimistic. You call me, agnostic and concerned.
But even that is optimistic.
But as to the court and this case, or these cases, the cyclo cases, a couple of things. Remember, of course, certiorari is a rule of 4. So it only takes 4 justices to hear the case. That's a sign that 4 want to hear it. It isn't a sign that more want to hear it. And you could ascribe very bad motives to those 4, and still, in this case, as was pointed out, you'd have a 4-4 tie, and the case would squeak through. So it's hard to read, and I don't know. When we were walking in, someone I was talking to wondered if one or more of these cases could become our terms Bush v. Gore. And interestingly, for me, I'm somewhat more worried worried in terms of the court, not doctrine, that the healthcare case could be Bush v. Gore, because for various reasons, the court could strike down the Affordable Health Care Act on grounds sufficiently narrow within the edifice of Commerce Clause doctrine that it wouldn't mess around with doctrine at all. It would really be like Bush v. Gore, a highly politicized outcome with no effect on doctrine. So it's judges at their most naked and in that sense dangerous, in a sense. Here, the judges are restrained by precedent. I mean, they'd have to really directly confront Grutter. And that would be the worst outcome, on the other hand. But if they're constrained by Grutter, then they either have to uphold this or they have to find a rather slender reed to shave Grutter, and the top 10 plan might look like that. Now, they could shave Grutter narrow enough there wouldn't be much left of it. But, you know, I'm not optimistic, but I'm not convinced that a disaster is on the way. But I think we should all tense up a little bit here.
David, you want to add anything to that?
Yeah, I want to echo it as far as maybe I gave you 1% of optimism, because that's about what I have. You know, we do recognize that only 4 judges are needed to grant cert, and so we have that bit of optimism. But I actually did not think that this case should even be granted cert, because there wasn't a dispute among any circuits. There's not rampant race-based diversity admissions plans going across the country that Grutter sprang or anything. You know, UT is one of only a handful of certainly public institutions. So to say that, you know, there's an agenda of at least 4, probably. But, you know, I'll close with that.
All right. Well, I'm sorry I brought up the issue of optimism. I go home somewhat deflated now.
Dark in the clouds.
But the alignment of the Department of Justice with the Fifth Circuit's majority ruling is a good alignment. And that's a part of where I draw my optimism. The folk that are bringing the appellants are asking the Supreme Court to reverse itself, and that's a very high charge that they're bringing to the Supreme Court. You got it wrong in Grutter, they're telling the court, and you've got to fix it.
Yeah, that's also what Garza said in his concurrence.
Yeah, and that was, well, I won't say anything on the record about that. But, you know, just because, you know, his criticism of the top 10% was entirely unwarranted. Nobody challenged the top 10%. And for him to include so much rhetoric in his opinion, I thought that was totally uncalled for from a Fifth Circuit judge. But I just want to add that, you know, the plaintiffs aren't necessarily attacking diversity all across the board. I think that it's a little bit more narrow, just like what Dean Sager said, which is, can you use race to the degree that UT says it's using race when you have a race-neutral plan like the top 10% that's working in their minds? You know, where does the deference to the universities lie? And I think that's going to be the ultimate question that Kennedy will restrict his analysis to.
Let's have one more
I
question.
just want to say 1 second. I'm not sure how it cuts, but it would be a mistake to overlook the literary quality of this event. You know, returning not to the institution, which was the law school, but to the campus where Sweat v. Painter was decided with a potentially historic opinion is a pretty interesting, hard to overlook that somehow.
One more question, and then we'll wrap up. Anybody? Yes, Mr. Norte.
I have a question for the panel. Let's say in a worst case scenario, the Supreme Court does say you can no longer use race admissions. Could we see proxies for race? And how true is it that using socioeconomic status would account for racial diversity? Could you touch on that?
All those other factors that you saw, you know, whether or not you come from a single family home and so forth, you know, SES, all of those certainly speak volumes when, and especially in Texas, they're very closely aligned with the racial demographics. Of course, you know, you have single family, Anglo families and so forth, you know, that's what makes them race neutral. But I think that it's particularly important for universities still to actually use those, you know, because to me and to many other critics of these types of plans, they don't actually use those. Because when you look at the SES demographics of people admitted under those types of plans, you know, it draws a lot of questions with the data. It looks very similar to the top 10% versus non-top 10% data. So it all falls on the university's appropriate use of those other factors.
And we're in a high poverty state. If we use socioeconomic status, it will be very competitive because our whites in Texas are low-income whites. And to the degree that there's a disparity for Latinos, we're the poorest of the poor, and so are African Americans. But the whole state has a 40% eligibility for free and reduced lunch. And Austin has a 40%. So Austin is an example of the depth of poverty that we have in our state. If that horrible scenario were to come about, that strict scrutiny review of issues of race, we go back to just put us all back down to the lowest level of scrutiny. Here's where my pessimism comes into place. I think Texas could mess even that up and still give causes of action that would arise where African American and minority, not claiming their race status, would still be fighting for access into higher education. And the example I give is the Claiborne case, which is a disability law case, where the U.S. Supreme Court refused in Texas to give the highest level of scrutiny to disabled folk who are applying access to residential, state-funded and state-operated residential settings. And even under the lowest level of scrutiny, the people with disability won against the state of Texas. So we have issues in this state that we can't even treat people fairly based on the lowest level of scrutiny.
Just two things. One is the law school passed through the era of Hopwood relatively well by a variety of things. One was a geographic commitment to South Texas and the Valley, which is genuinely that and can be justified independent of its ethnic and racial implications, and has a commitment to the Valley in a second way, which is important here, which is not just admission, but recruiting. So as dean, I got on a state airplane, which sounds luxurious, but I think of as heroic. The state planes fly at exactly the height of the weather, it turns out. You know, I got on a state airplane 4 times a year and would each time give speeches and meet students at 4 schools in the border towns and valley, recruiting and reaching out. So pushing the range of people who think about law and apply to the law school, think about college and apply to UT. And then geography is, I think, a defensible non-racial criteria, even though it is one that would carry racial or ethnic overtones. It's got independent justifications given the economy and the educational regime and lots of aspects of its regional importance to this state.
Thank you. One more really important point that I don't know how this skipped over me. UT's use of race, they actually, this is their own evidence and testimony, they use race for anybody. It's not confined to Latinos and African Americans because of the racial experiences that they bring. So for instance, if you are an Anglo at a majority-minority high school, they will look at those experiences in a preferential manner. So it can benefit Anglos just as much as it can benefit Latinos, just as much as it can benefit Asian Americans and so forth. And that's a very, very important point that the plaintiffs have really have ignored.
Thank you very much. Let's have a round of applause for our panel.
That was fantastic. Thanks again to our panelists. Next, we're going to have 2 breakout sessions. In this room, we'll have the panel on voting rights and redistricting. In the next room over, 202, this way, we're going to have the panel on judicial clerkships. So for the next 5 minutes or so, please move to the panel to which you'd like to attend. Thank you.
Good afternoon, everyone. I have housekeeping announcement before we get started. The student attorney mixer has been moved to the courtyard right across from here, so the door to the right when you exit will be where the mixer is immediately after this panel concludes. So this is probably the panel I'm most excited about, just because it's an issue that I care a lot about, and I took a class with one of the panelists, Professor Martinez, though I don't know if everybody calls him Professor. But this is obviously a very important issue for the Hispanic community, so I hope you all take this very seriously. And I want to introduce our moderator, who has been a mentor and almost like a sister, Gabriela Moreno-Saenz. She is Director of Advocacy and Policy for Christus Health. She's a graduate of St. Mary's undergrad and UT Law class of 05, where she was an active CHLSA member and really encouraged me to get involved in CHLSA during my law school years. So thank you, Gabby, for being here to moderate, and let's get started.
Well, the good thing about today is that we actually have maps to talk about. I'm sure we would have had maps to talk about before, but I think, like Bianca said, this is such an opportune time for everybody to get together and hear from some not only state but national experts on what is going on with redistricting in Texas. So I'm not going to do a lot of talking. I'm going to pass it on to our experts and make sure that y'all get the opportunity to engage. But to give you a brief bio of everybody that is here today, obviously we have, many of them are without introduction, but as you all know, the Honorable Congressman Charlie Gonzalez. He was St. Mary's Law grad. He is an attorney. He is current chair of the Congressional Hispanic Caucus. He is a legacy in San Antonio and will be very much missed as a sitting congressman. But we thank you for everything that you have done. Sitting to his left is Ray Martinez. He is a former vice chair of the Federal Elections Commission, an adjunct professor. Many of y'all have seen him in your classrooms. And he's also the chief of staff for State Senator Judith Zaccarini out of Laredo. Dean Sager to your left, who, again, needs no introduction. He's the nation's constitutional scholar and theorist. So I think he'll have some great things to say that probably will be quoted in the newspaper tomorrow at some point. He came to us from New York, and he is, we are lucky to have him here in Texas. To his left is Luis Figueroa, who is a UT Law grad as well. I also run into him at the Capitol all the time. He is a MALDEF senior attorney, and he is very active on this front. So we're going to go ahead and pass it on. I think how we're going to start today is we're going to go to the left and give you each some time to kind of give us a little bit about your thoughts. Congressman Gonzalez.
Thank you very much, and thank you very for the kind words. This is my last term, a lot of reasons, but quickly, to be part of this panel is incredible, and to be here before you. I'm around lawyers, judges. I saw Xavier and Jan here earlier, and of course the dean. So I'm surrounded by a lot of expertise, and that means I got to be careful what I say, because you'll call me on it when I'm totally wrong. Unlike in Congress, where we can basically say anything, it doesn't have to be based on facts or figures. It just doesn't matter. One real quick observation, because the previous panel was just excellent as heck, and I know all of you, many of you, of course, as law students and pursuing a career in law. You know, there are three branches of government, and I've said this often enough. One of them has been basically set aside exclusively for our profession, the judicial branch. That is an incredible responsibility that's been laid on the shoulders of lawyers. And so, think in those terms. And if you have the three branches of government, and if you were to say, well, you know, I'm seeking justice, equality, and fairness, which of those three branches do you go to? And I guarantee you, in the final analysis, it will always be the judicial branch. It always has been, historically speaking, that actually does provide access and really the last resort for any of our citizens. So it's so incredibly important. And just thank you for pursuing a career, and thank our panel for what they've done in their careers and will continue to do. I'm going to be very, very brief. I'm going to be limited on just what I refer to as the effort throughout this country, and even here in the state of Texas, which is not unusual, on voter suppression. You also had a discussion by the previous panel about how constricted, how restricted, how proscribed will the consideration of any of these laws that will be challenged all the way up to the Supreme Court? I like to believe that they're going to do the right thing for all the reasons, and they're going to follow precedents and such. But when it's all said and done, it is always going to be about political power. Now, you still get the best deal out of the judicial branch, but it truly, truly, in the final analysis, it's going to be about political philosophy. It's going to be about political power and access to a full and complete life of opportunity in this country. Now, I'm going to tell you about the Texas voter ID law, which I know Ray and Luis would be very, very familiar with. But this is what we're faced with. And I think the thing about being a pessimist or an optimist quickly, it's the old thing about, I used to be a cautious optimist, now I'm just a confused pessimist. But that's the way it is today. But on December 31st, 2007, Justin Levitt wrote a piece for the Brennan Center for Justice. Because up before the Supreme Court was the Crawford case, of course, on the Indiana voter ID law. And in essence, this is what he said. Because there was an analysis of the proof and the evidence that had been presented before the Supreme Court on the requirements of the Indiana law and its impact and its purpose. And this is what Levitt said. But not one of the sources cited shows proof of a vote that Indiana's law could prevent. That is, not one of the citations offered by Indiana or its allies refers to a proven example of a single vote cast at the polls in someone else's name that could be stopped by a poll site photo ID rule. Indiana and its allies recited hundreds of examples of election problems that could not possibly be solved by Indiana's law requiring photo ID at the polls. These include allegations of ballot tampering by election officials, erroneous vote tallying, vote buying, voting by citizens referred ineligible by a conviction, registration by non-citizens, multiple voting in the voter's own name, absentee vote ballot fraud, and mishandling. Often, when these allegations are investigated, they reveal not fraud, but rather mistake or administrative error. But even when these reports are accurate, the misconduct they describe could not possibly be prevented by the challenged law, the photo ID law. So you go, wow, this is going to be all right when we get to the Supreme Court. No. Fast forward. And this is the Bloomberg Law blog, and the individual's name I have it here somewhere, but let me just basically, it's April. Fast forward. Ruling comes out. Indiana law is good. Indiana's all right. And I don't have to tell you how many states that have followed Indiana. And this is what the writer said. In discussing the claim that ID laws are needed to combat voter fraud, Justice Stevens noted that the record in the Indiana case, quote, contains no evidence of any voter impersonation fraud actually occurring in Indiana at any time in history. And then, just like the writer had said earlier, any and all examples, historically speaking, of fraud would have never been addressed, remedied, avoided, cured, whatever you want to say, by a photo ID law. So you're students and you're wondering, you don't have evidence, why would you need the law? But it goes back to what that previous panel probably touched on. If you have a compelling state interest, and I have an expert, I have the dean here who can give me some guidance on this, then many times, how the law is applied are the facts that are presented at that time. And if you couldn't really show individuals that might be impacted and deprived of the right to vote, because this is our only hope going forward, and of course pre-clearance and the Voting Rights Act and such. But it's very interesting. You cannot count on the fact that the state of Texas and that the George Bush administration, after 5 years, couldn't prove to you one case of voter fraud based on voter impersonation at the polls. We have that law in Texas. We can go into the specifics after I sit down and the other panel members get to speak about the potential impact that it's going to have on many in this state, the impact that it's having in other states, but the problem is still going to be, even if we can show that people have suffered and people that are eligible to vote are not able to vote, it's still very questionable what this Supreme Court may do when we go back up and present this issue again for their consideration. As I said, I was going to be very brief, get the other panel members, because they're going to be speaking maybe on some other aspects of what I call voting rights, voting suppression, and then we can open it up to Q&A. Thank you very much. God bless.
Well, thank you very much. I'm delighted to be here and quite honored to be a part of this particular panel. And although I don't live in the 20th Congressional District in San Antonio, I can tell you that I regard Congressman Gonzalez as my congressman, as he is for all of Texas. And you will be sorely missed, sir, in Congress. And we know that you will continue to work as a tireless advocate and as a champion for not only the people of San Antonio, but now for all of Texas in a very distinguished way. So thank you for all that you've done. What I want to do is also be very brief, tell you a little bit about the work that I have done in the voting rights arena, and I think the value of this kind of a panel is to do some Q&A. So I hope everybody's thinking about questions to ask, whether it's on redistricting or on photo identification laws or the like. As Gabriela said, I have worked in a variety of capacities in my background. I actually worked in D.C. during the Clinton administration. I started in 1992, 20 years ago, as a campaign operative for the Clinton-Gore campaign in 1992. I was a state director in New Mexico. And from there, took a job in the Clinton administration, worked the entire first term in D.C., and then came back to finish up my law degree at the University of Houston. And eventually found myself back in D.C. in 2003 as a commissioner of a new federal agency called the Election Assistance Commission. And my guess is that if I took a poll of this room as to how many of you have heard of the EAC, I'd be surprised if it's limited to the few students, maybe just one, Bianca, that have taken my class. And if you did take my class, you better raise your hand and know what the EAC is. The EAC was created, and obviously the congressman actually knows very much about the EAC. He's sat on the House Administration Committee for a number of years, if I'm not mistaken, Congressman. And during my tenure on the EAC was a very important supporter of the work that we were doing on this commission. But I do want to talk about that just for a few minutes because it relates directly to the issue that we're talking about today. The EAC is a small, obscure little agency created in 2002 as a result of the Bush v. Gore presidential campaign. And that case was referred to in our previous panel. In 2002, Congress, after a series of field hearings around the country, decided that it was important, based upon what we had learned from the election of 2000, the Bush v. Gore, the close margin, and what we found out about voting systems and in essence, the mechanics of our democracy, not how we vote, D or R, but the way we cast our ballots, seemed to be in serious disrepair. And so Congress, after a series of panel discussions and hearings and a bipartisan panel chaired by President Carter and other distinguished leaders back in 2001, leading up to this legislation in 2002, Congress passed the Help America Vote Act of 2002, so 10 years ago. In fact, we celebrate our 10-year anniversary for this historic law this year. And what this law did, without going into too much of the specifics, but it was historic in the sense that it was the first time that the federal government had ever provided funding to state and local governments to improve how we run our elections. And so for the first time in the country's history, there was funding going to state governments and then trickling down to local governments to, for example, improve the voting machines that were used. Why is that important to minority voters? Why is it important to Latino voting rights? Well, prior to 2002, during the 2000 election cycle, for example, most jurisdictions around the country used voting technology that was called punch card voting systems. And what we've seen from plenty of studies, academic studies and think tank studies, is that the use of punch card voting machines actually probably had a negative impact upon the voting rights of particularly minority communities. And this was true not just in Florida, but it was true around the country. So when Congress passed the Help America Vote Act of 2002 and provided funding for the first time in our country's history, we were able to move away from these antiquated voting systems, not just in 1 or 2 states, but throughout the country, away from antiquated voting systems which were shown to have a disproportionate impact upon minority voters. In disenfranchising minority voters, we're able to move to more modern voting equipment, which brought a whole set of new problems like paperless DRE systems, paperless touchscreen machines. But that's a topic for another panel. The fact of the matter is that HAVA, the Help America Vote Act of 2002, helped, I think, to improve how we conduct our elections, the mechanics of our democracy, and help to hopefully re-enfranchise minority voters around the country and other voters around the country who are using antiquated systems. The other thing that HAVA did was to give state and local governments a set of administrative guidelines on how to do certain things when it comes to election mechanics. For example, it requires every state in the country to have a statewide list of, an official statewide list of registered voters. So prior to the passage of HAVA in Texas, there were 254 official lists of registered registered voters in the state of Texas. Why? Because there's 254 counties, and each county controlled their list of registered voters. Well, HAVA said, you know what, that needs to be more transparent, and it needs to be the responsibility of not 254 people, or in some cases, perhaps even larger numbers of individuals. I think it's the state of Michigan that actually governs their elections not by counties, but by townships. So you have 800 and something local jurisdictions. Congress decided with passing this law that there ought to be one person responsible for the official list of registered voters. And that person ought to be your chief statewide elected official, which for 38 states happens to be the Secretary of State, and that's who it is in Texas, is the Secretary of State. So that's another example of what the Help America Vote Act did to, again, try to bring transparency to a process that we had seen, for example, in Florida and Georgia in 2000, with the purging of voter registration lists had a disproportionate impact and disenfranchised particularly minority voters. So again, this obscure little federal agency created by Congress in 2002 was given a fairly significant responsibility in that it was our job to try to improve the voting technology, to try to implement statewide voter registration lists and bring greater transparency, to implement what's called provisional voting, which prior to the passage of HAVA was a state-by-state exercise rather than a requirement, as it is now under federal law. And we can talk about exactly what provisional voting is if you haven't taken my class, or please take my class. It's going to come up again this fall. So these are the things that I worked on as a commissioner for 3 years. Worked very closely with Congress, in particular the House Administration Committee and the Senate Rules Committee, which has jurisdiction over this particular federal agency. I'll close with that and simply say that, and we can talk some more during Q&A, but this is a historic time for minority voting rights and Latino voting rights generally. From a legal perspective, you have the Supreme Court of the United States that will likely consider the continued validity of an important section of the Voting Rights Act, Section 5, and Louise can talk in much greater detail about this. The Supreme Court will also likely decide, the validity of Texas photo identification law, and the Congressman talked very eloquently about the impact that is likely to have, and Louise can talk some more in detail about that issue. There are also issues that you may not have heard about, but states around the country are imposing documentary proof of citizenship requirements at the point of voter registration. So what does that mean? Well, my 91-year-old dad, who passed away a couple of months ago, he was born on a ranch outside of Laredo. There's a birth certificate that documents his birth because the Catholic Church cared about baptizing children, but the county he was born in didn't much care to document his birth back in 1920. So if he were to have to prove his citizenship with a piece of paper, if that law came to Texas, which is now in Arizona, it would be a problem. And that's something that we should all think about. I'm not here to persuade one way or the other, whether it's right or wrong, but I am here to say you ought to be aware of it, and I hope that you are. So I'll close with that and turn it over to our next speaker.
Thank you.
Hi, everybody. I was asked to talk about the role of the Constitution in voting rights here and now. And actually, it's not a very big role, I think, although perhaps potentially in one area. And I'm going to actually just do a kind of survey. It seemed to me there were sort of at least 4 contexts in which the Constitution could be invoked. And only possibly in one is it likely to be very salient in our immediate future. One of those that's easy to overlook is a case called Shaw v. Reno. And Shaw, which excited a tremendous amount of controversy at the time and resulted in Justice O'Connor being vilified by people who support equity in voting rights. I actually had more sympathy with Shaw than most people. Shaw was a very interesting case because it was an instance in which a state, acting under its obligations under the Voting Rights Act, among other things, had designed not just a racially conscious district, but a district which was vividly racially conscious. And I do mean that. I don't mean statistically, I mean vividly, because it was this enormously long, thin, weird voting district, which had been imposed on the state, and there was no possible understanding of it, other than it was in fulfillment of a certain vision of racial equity in districting. And Justice O'Connor struck it down. Not because it was racially conscious, not because it was in the name of racial equity, but that it was sort of too vividly so. I don't think those were her words, but that was the idea. And it wasn't her notion. Justice O'Connor had a powerful moral compass, and sometimes that compass was stronger than the conceptual apparatus that could sort of support it. And Shaw was such a case, because basically what she was thinking went something like this. There's something about the ethic or ethos of racial relations and human relations and voting rights in the United States that would make us very unhappy if we had voting districts that were literally racial. You know, suppose we said there are 42 congressional districts at large in this state, and 6 of them will be occupied by the following racial groups, and 7 of them this group. Fishermen will have these. You know, we're going to abandon geography and just let you have racial districts. She thought that was an appalling idea, that somehow the ethic of that was inconsistent with American democracy. And she thought this weird strip running through the state was somehow too big a step in that direction. Rightly or wrongly, Shaw excited tremendous unhappiness. It's had very few real consequences. It didn't have hard edges. That kind of extremity was states backed away from and seldom needed. And the result was that Shaw v. Reno has very little consequence on the landscape. Although I'll be interested to hear, you know, whether you think there's more viability there than that. But it doesn't seem to loom large in Texas or in the United States, despite its one-time great social, political, and for us constitutional scholars, scholarly perturbation. The second one is the most serious one, and that is whether this is the election cycle or not, and I doubt that it is. Sooner or later, Section 5 of the Voting Rights Act is going to really be under intense scrutiny by the United States Supreme Court. And the question is going to be whether it is an excess of congressional authority under Section 5 of the 14th Amendment or Section 2 of the 15th Amendment. And there are going to be two sources of pressure. And I think we've got a real expert here to talk about this. But the two sources of pressure are going to be, one, I think quite unjustifiably, the Supreme Court over the course of the last decade or so has taken an increasingly narrow view of Congress's authority to act on behalf of racial justice under Section 5 of the 14th Amendment, and to act under the press of civil rights and justice in general. So the congressional authority readings by the court have grown ever more narrow, I think quite implausibly. If this court thinks that activism is a problem, despite Congressman Gonzalez's and my great love of courts, doesn't want, and I share his love, doesn't want courts in there, then it should welcome Congress's partnership, genuinely welcome it. And it's a conceptual mistake for the court to be as ever more wary as it is, but it is. So the general notion of congressional authority is contracting. And in the case of Section 5 of the Voting Rights Act, there is the special problem of exactly how long you can take the legacy of voting discrimination that prompted the Voting Rights Act in the first place. How long you can, in effect, put states of the United States under a special statutory receivership and scrutinize their conduct. Doesn't their vulnerability to special scrutiny expire? And there's an analogy in the context of Brown versus Board of Education remedies, where the court has slowly begun to say, look, those remedies die at some point. And I think the combination of the temporal overhang of Section 5 and the court's general skepticism about congressional power is going to put pressure on Section 5 of the Voting Rights Act. And that may be the most robust or the most powerful constitutional issue outstanding at this point. The other two, I'll go more quickly. One is, you look at Texas, for heaven's sakes, and you say to yourself, surely it's unconstitutional for the Republicans, for the Democrats, or for any party to turn congressional and state and districting into a political exercise. It can't be the case that there's no limit on the party in power's ability to entrench its power by manipulating districts. And the Supreme Court, in some bizarre way, seems to agree, but it's bizarre. It agrees in the sense, I think it's very possible a majority, maybe even a substantial majority of the legislature would say, of the court would say, you're right, there's got to be some constitutional limitation on this activity. And there are surely state legislatures, see Texas, stepping over that line. But a plurality of the court, when this issue came before it in Veith, said that this was a political question. Now, what it means for this to be a political question isn't that there aren't constitutional issues. It is that the court can't adjudicate them. And a four-justice plurality said, we've looked and we've looked. We don't think there is anything approaching a judicially manageable test to describe the limit at which a state legislature trespasses on the Constitution. One justice, Justice Kennedy, joined that four, and his position was different in an interesting way. He said, I agree with my colleagues, these four colleagues. There doesn't seem to be any test available to this court, but I'm not prepared to announce this as a political question for all time. I'm saying that right now, in the context of this case, I don't see a manageable standard, and so this is a kind of political question pro tem. But if in another case, at another time, a new technology, a new argument, or even worse behavior is on the table, I'm open to hearing about it. So there's an unstable, but probably durable, setting this aside on political question grounds. And the last thing to say, to talk about, is the very important point raised by Congressman Gonzalez, and that is what he called voter suppression measures, like voter ID. And there, the court has been a non-performer. And it isn't strictly political, by the way. It is perhaps partially political. But it seems to run deeper than that. I think the court, in general, has been very worried about putting itself into the middle of a complex administrative matter in the middle of democratic governance. And so the court, you know, one of the great distinctions of the Warren Court were its voting rights decisions, but they all had a certain form. You don't pay a voting tax, you don't get to vote. And the court said you can't charge for the franchise. You're a member of the military and you're stationed in a state, but you shouldn't otherwise be there. You wouldn't otherwise choose to be there, and Texas says you can't vote. The Supreme Court says you can't exclude people on that grounds. You haven't lived in the state for 6 months. The court said you can't exclude people because they haven't marinated in local juices. So there were all these kind of categorical exclusions, and the court said you can't exclude people from the franchise. These are all more subtle in this curious way. I think the court could have a more robust jurisprudence, but it's not as though it's literally impossible to produce a photo ID. And it's not as though, it's not like charging for it. Everyone knows the reason it was done, everyone knows the consequence, but the court has been very unwilling in these softer, less categorical, sort of administrative democracy cases to take a single step forward. And you know, I predict that isn't likely to change. And I think that's a misfortune. I don't think the court has to be as wary of this jurisprudence as it is, but it's quite deep, its wariness. And I think the congressman did a good job of describing and bemoaning that fact. So those are the four contexts of the Constitution. Only one of them looks like it's going to knock on our door in the near future, and it's the Section 5 of the Voting Rights Act vulnerability to Supreme Court review, which I think is a substantial vulnerability. That's altogether not a beautiful picture to paint, but I think it depicts the landscape pretty accurately. Thank you.
Well, first I want to say thank you for having me. What a great event. I want to thank the State Bar and the students here who put this together. What an esteemed panel. I mean, to have my hometown congressman and who I remember when I was an undergrad when he got elected, and the legacy of you and your father, it is surely the end of an era. Thank you for all the work that you've done in your work in Congressman. Ray, who I often go to as a confidant on not only election issues but on higher education issues, both when you were at the Election Assistance Commission and then when you worked for Senator Zaffarani. And my former professor, Larry Sager, thank you for all the work you've done. So it's a real honor to be on this esteemed panel. I wanted to bring a little bit of a perspective from the legislative and litigation front. MALDEF, as many of you all know, has been in the forefront of these battles, both in the courtrooms and in the halls of the legislature. And I thought I'd just take it from most controversial, least controversial. We are always in the mix of the most controversial issues. And so I thought I'd start a little bit about redistricting, go to voter ID, and then a little bit about election protection work, and a call to you as students and attorneys to be involved in the election process. And so I'm going to talk a little bit about that. First, I want to talk a little bit about redistricting, and I think the one thing that needs to be stated is the tremendous growth. The demographics are what they are. 65% of the growth from 2000 to 2010 was Latino growth. It's been said over and over, Latinos were responsible mainly for Texas being the biggest winner in the reapportionment and gaining 4 new congressional seats. Despite that growth, the legislative maps did not really reflect that growth or the communities of interest that came about. Of course, the legislature was in charge of 4 maps: the State Board of Education, the Texas Senate, the Texas House, and the congressional map. With the State Board of Education, the seats were so large, it essentially was not very controversial, and the map came out and have been pre-cleared. With the Texas Senate map, there was a dispute about one district, Senate District 10, that was challenged by some plaintiffs, and a compromise has been worked out. But again, not too controversial. It largely kept the Senate districts intact of where they were historically. The two big controversies were the Texas House and Texas Congress. On the Texas House side, despite Latinos being 65% of the growth, despite this tremendous outpouring of the need for new Latino opportunity to have their voices heard, there were drawn 2 less Latino opportunity districts out of the state House map. Those districts included House District 33 in Oasis County, which is in Corpus Christi. We fondly refer to it as NEMO, because you'll see a tiny little district inside Corpus Christi that has a very strong Latino population in the benchmark, meaning the map that was in existence in 2010, and then you see a legislative map and NEMO's gone. And we are all asking, where did NEMO go? Where did NEMO go? We got to find NEMO. Why are they taking away our Latino Opportunity District? Well, NEMO ended up in Houston as an Anglo district, and to us was a clear violation of the Voting Rights Act of a district that we had before that was taken away. The other district that we felt was removed was House District 117 in San Antonio. That was a little bit more subtle. That was a district where the numbers were essentially the same, meaning the CVAP numbers and the Spanish surname voter registration. In fact, the testimony and the evidence showed that the incumbent and the leadership wanted to keep that district at 50.1% Spanish surname voter registration. Not a penny more, not a penny less. And the reason for that was at 50.1, they could manipulate Latino turnout in certain districts and certain neighborhoods to ensure the incumbent would be able to win the election, but still claim it was a Latino opportunity district. And the evidence bore that out, and we believe that was a violation of Section 5 of the Voting Rights Act. On the congressional side, again, tremendous growth, 4 new congressional districts. At the end of the day, at the end of the map, no new districts were drawn for Latino opportunities. They did add 1 district along I-35, but they took 1 away in Congressional District 23. And even though I'm a lawyer, I still do a little bit of math. +1 minus 1 is still 0. And so despite the attempt to say they added 1, you take 1 away, that doesn't equate to an additional district. So that brings us to the litigation. And of course, many of you all know that when you finish with the map, you have to get pre-clearance, meaning you have to get approval from the Department of Justice or the DDC court in DC. And the process took a very long time. The standard that they were using there was discriminatory purpose or discriminatory effect. And I think a lot of people forget about the discriminatory purpose. There was a lot of evidence of it being purposely done. And specifically, we'll talk about Congressional District 23. In Congressional District 23, there was an email from the various leaders from the Congress, attorneys representing the congressional delegation to the House leadership, talking about a nudge factor. And it was very similar to what they did in HD 17 on Congressional District 23. They wanted to make it look like a Latino opportunity district. So again, there was emails about a nudge factor of don't reduce the Spanish surname voter registration, don't reduce the Hispanic CVAP numbers, but let's go in and out and carve out districts where Latino turnout is high, and let's put the high Latino turnout areas in a different district and put the low Latino turnout districts into CD23. When we analyze the elections, you look at racially contested elections, you see that CD23 no longer performed for the Latino candidate of choice. And so that to us was the smoking gun, the legislative purpose. And then the San Antonio court took over the Section 2 part about whether there should have been additional districts and whether or not there were other legal defects in the 14th Amendment. We had an interim map. The interim map was supported by most of the plaintiffs. The standards were not very clear about what you use to draw an interim map, and that is a map to get us to the 2012 election. When we went to the Supreme Court issued new mandates that really had not been in place before and essentially said, you have to use the legislative map unless there are specific legal defects that you can point to. And with that, we felt that with that standard, the court was subject to no longer being able to look at certain policy distinctions. And when you're in a legislative process, you can look at certain things such as whether or not a particular landmark is in a particular district, or whether a certain, what they call economic boom or economic drivers in a certain district. But those don't necessarily create legal defects. And so when the map came out, as was struck down by the Supreme Court, we and MALDEF, representing the Latino Redistricting Task Force, agreed to a new congressional map that drew 2 new Latino opportunity districts. And that were Congressional District 35, which runs from San Antonio to Austin, and Congressional District 33 in the Dallas-Fort Worth area. And a restoration of Congressional District 23, so it's no longer +1 -1 0, it's a true +2. And that was what we were looking at. And there's some discussion about Congressional District 25, which is where we're in right now, which is the Doggett's district. I think for us, it was put into the context of looking at what Professor Sager was talking to us about. Section 5 has been under attack for a very long time, and we felt that the Section 5 could not be stretched to encompass a district where Latinos and African Americans don't constitute a majority in a primary election. When that occurs, you're basically saying that the Voting Rights Act covers districts where Latinos and African Americans are not electing their candidate of choice in a primary. And we felt that while we don't have an opinion on whether 25 should be drawn or should not be drawn, from a legal point of view, it was not something we could say was absolutely protected. So that's where we are on the compromise. There was a House compromise plan. The San Antonio court drew our congressional compromise plan. On the House side, they did not draw our compromise plan. They did not restore NEMO in House District 33. We think that that's something that needs to be addressed when the DC court rules on preclearance, and we'll fight for that when we get to the permanent map the next round. But for now, we have maps. We're going to have primaries in May 29th, and we'll be able to allow the voters to make their choice in the election. Before I wrap up, I just want to talk about a couple of more things, and that's one was the voter ID thing, and I think Congressman Gonzalez and Ray talked a little bit about voter ID. The one thing that I think is sad and perhaps ironic is that the Help America Vote Act, which provided funds to states to improve their election process, is now being used to educate people about the voter ID law, the photo ID law. And I don't think that was really the purpose of the Help America Vote Act, was to educate something about a law that potentially had a discriminatory impact. But where it is right now is it's seeking preclearance in Section 5 in the DDC court. The Department of Justice has asked the state for specific information to show it doesn't have an effect on Latinos and African Americans, and the state has been unable to demonstrate data that it doesn't have an impact. I do think that in terms of the litigation, the case law on it, that the courts have been very reluctant on voter ID, but I think the one thing that Texas has that's separate from other states is the fact that we're a covered jurisdiction under Section 5. It's a slightly different standard. I think there is evidence of discriminatory purpose, and I do think that, and the data comes out, that there is a potential for discriminatory impact. But we need to make the case in a much stronger way than we have and the advocates have made in other cases. The last thing I just want to talk a little bit about is election protection. We have a lot of law students here and attorneys here, and the one thing that MALDEF does every election is election protection work. We take law students and we take existing attorneys, we train them on the election law under state law, the Voting Rights Act, Help America Vote Act, disability laws, and encourage them to do some poll monitoring at the election day. And when complaints come in, when people are asked for identification that they're not required to ask for, when people are turned away from the voting polls because they're at the wrong precinct, or they're turned away because of something that they're wearing. We had an incident in San Antonio where an African-American lady was told to take that do-rag off when she went to go vote, and was so embarrassed that she ended up not voting, and called our offices, and we were able to work with the county and the precinct judge and get that person to vote. And I think it's very helpful to have law students and attorneys out, be our eyes and ears on election day. So we're going to do trainings throughout the law schools in Texas, and we encourage you all to get involved in that. And I appreciate if there's a point of contact, you could let me know so that we can really do a good job of protecting the right to vote on the ground. And I think that's what it ultimately comes down to. It's about tying this back to redistricting and voter ID. Ultimately, it's about having the opportunity to have your voice heard, that the representation is there that reflects the voters. And I think at the end of the day, MALDEF is committed to that, and we are deeply involved in the practical and legislative processes of that. And so with that, I will end, and maybe we can talk a little bit about some of those cases that Professor Sager talked about. But thank you very much for having me.
We will go ahead and open up for a few questions.
I just wanted to maybe have you, Mr. Figueroa, expand a little bit more, almost as a comment on Dean Sager's remarks about the continued validity, what the Dean called a temporal overhang for Section 5, where it seems like a lot of people will maybe even have convincing evidence that if the covered jurisdictions under Section 5 are maybe more or less discriminatory than another, if that's still a valid reason for continuing its presence. What would be your argument for Section 5 continuing to stand up to constitutional scrutiny?
Absolutely. So the first thing I'm going to say is that Section 5 of the Voting Rights Act has been the most effective civil rights law of the civil rights era. You can point to any number of those laws, and every civil rights lawyer would tell you Section 5 has been the most important. And that's because what happened before Section 5 is that you have an election violation, you have a voter suppression effort, and it goes into effect. And then you have to prove that that is going to have a discriminatory impact afterwards. So you've already had the voter suppression, you have to do expensive litigation, you have to prove up the Section 2 standards, which is pretty burdensome. Section 5 is that safeguard, and particularly in a jurisdiction like Texas, which when we wrote a report for the reauthorization of Section 5, was the second leading violator of Section 5. Texas has a long history of discrimination, and I believe the only thing stopping from a lot of laws happening at the Texas legislature, and maybe Ray can talk a little bit about this, is that Section 5 provides that barrier. And we're talking about proof of citizenship to register to vote, address matches between driver's license and voter registration cards, efforts to include more documents to vote. All these things that wall is Section 5. Now that said, there was a case that went up on the constitutionality of Section 5, and that was the Austin Northwest Municipal Utility District that went up. And there was some hostility to Section 5, but I don't think we should underestimate the fact that it was upheld. The jurisdiction was allowed to bail out, but they didn't strike down Section 5. So I don't think we should say, well, we should just give up on Section 5, or that we should allow things to occur because we don't want to challenge it. But I do think we should be careful in terms of what we consider to be protected. And so we were very concerned about saying Section 5 protects certain districts, or Section 5. I think we need to be careful about stretching Section 5 out too thin, that the justices are going to find an opening to say, okay, if that's what Section 5 means, we're going to strike it down. And so we are being conscious about what Section 5 does mean, what was its true intent, and the fact that that every single senator voted, it was a unanimous vote in the Congress. There was a huge record supporting Section 5 of the Voting Rights Act. Discrimination is still occurring. I don't think there's any doubt about that in the voting context. So we hope that Section 5 will be around for at least another few decades until we really do demonstrate that Texas and other states that are covered have a better record when it comes to discrimination. You want to add anything to that?
Yeah, I mean, I will simply add that I completely agree with Luis that the case can very compellingly be made for the validity, the continued validity of Section 5 of the Voting Rights Act. In the previous panel, Dean Sager coined the phrase concerned agnostic about his, I think that's about right, Dean, about his position regarding the Fisher case. I would say that I'm a concerned pessimist when it comes to what the Roberts Court will do with Section 5 of the Voting Rights Act. I think it's likely, I think there's a target on Section 5, and that's a completely separate comment from my personal view that is in complete agreement with Luis that Section 5 continues to serve a very important and compelling policy purpose and should be upheld. And in fact, was quite not unanimously, but quite vigorously in 2006 when the Voting Rights Act was renewed by the United States Congress. And so, but I'm concerned, and I think that we will see it under assault, and I would predict that the Roberts Court will find a way to, and maybe Congress ought to act if Democrats perhaps take back Congress in some capacity in November. Perhaps it's time to act from a policy perspective and maybe think about some greater vigor, some greater ways to bail out that would reinforce from a policy perspective the idea of jurisdictions being able to bail out with a lot of bells and whistles around that particular bailout option. So maybe there's a way to deal with maybe it's better to in a sense give up a little bit on the bailout procedures to have a court that will continue to uphold the validity of Section 5.
And quickly, and Dean, as far as the Voting Rights Act, look, that thing had to be reauthorized. How long ago was it authorized? A couple of years ago. Congress reauthorized it. Now there was opposition to the aspects that we're talking about. Congress still reauthorized it. And I forget if we reauthorized it for another 20 years or 45 years, whatever it is. So the question then goes, if the United States Congress, which the judicial branch will defer to because of judicial restraint and all those wonderful principles that the legislative branch takes advantage of the judicial branch when we are true to them, it's a curious question, isn't it? When the United States Congress reauthorizes the Voting Rights Act for an extended period of time, and then you're revisiting the attacks on that act within just a few years after reauthorization. I think that's just curious. We'll just see how it plays out.
I mean, let me say, as a matter of a sound structural view of our constitutional order, I think that the Voting Rights Act is fully within Congress's authority, but I don't think that view is solidly held by the Supreme Court. And I do think that it may be important to make Section 5 dead so that it doesn't break your argument. I mean, and it is the case that this is a court that struck down the Religious Freedom Restoration Act, which incidentally I think was the right decision, striking it down, but for totally different reasons. And it's the court that struck down the civil rights provisions in the Violence Against Women Act, both of which have been enacted by Congress. So it's a court that is prepared to rebuff Congress's partnership in civil rights. And as I say, I think all of its disposition should be to the contrary. And I think it's very important for Louise to point out, and I hadn't really taken account of it, that the voter ID in Texas will be under Section 5. That ought to be an instance. If the court can't find the mechanisms to act, it ought to welcome a congressional administrative justice department partnership. But I hope you're right, that there'll be the kind of institutional comedy and deference that there should be in this area.
I think we have time for one more question. Anybody out there?
In light of the fact that the redistricting did not establish a bright line standard with regard to partisan redistricting that Justice Kennedy is so looking for, will there ever be one? Or is this a lost cause?
I mean, I'll just say that I don't think the court has found the limit to partisan gerrymandering. I think that they view it as politics is politics, and the Democrats will do this, and the Republicans will do it, and whoever's in power is just free to do whatever. The one caveat, I would say, is the Latios v. Cox decision that said that if you start messing with population deviations, remember every district is supposed to have the exact same population in Congress, and in the state house you get a little bit of a percentage, +5 or +down on population deviation. That if you start messing with deviations in order to achieve a partisan gain, that was ruled unconstitutional under the one-person, one-vote. But with that said, I don't think they have the stomach to really get into what is intentional discrimination in a partisan construction. And I think it is a little difficult to determine what is a partisan gerrymandering. And I'll say that when we went up in Lulac v. Perry, which was the challenge in Texas the last round ago, everybody was focused on the mid-decade redistricting and how that was going to be too much for the Supreme Court. But essentially it was struck down because of the racial discrimination in Congressional District 23. And that's the thing that bothers Kennedy. Justice Kennedy, I think, was very perturbed by the use of race in that district. And I think that that bothers them more than the fighting between the partisans.
I do think that, if you wanted a bright line, or at least you could presume against mid-decade redistricting. That seems a piece of cake for the court to say, right? You don't know anything, that shouldn't be so hard. So that is one possibility. And, there might be a combination of extremity of state behavior and, competence of litigators, and there might be a breakthrough. I'm not very optimistic, but, there was famously the inability of people to go after what became one person, one vote for a long period of time because the court kept saying it was a political question and we don't enforce the guarantee clause. And then along came Baker versus Carr, Justice Brennan, and a rigid mathematical formula that caused a lot of grief, and which we smile on a little less now in retrospect than we did then. But there was suddenly all this became open to adjudication. The population of the staffing the Supreme Court could change. We're going to, depending on the direction of the presidential election that we're encountering, it's possible that out of all that and some really egregious behavior by a state, we could find adjudication, but it looks pretty decisive at the moment.
Well, we are having a reception right outside here, and I'm sure you can ask me questions after that. I will just want one parting word or one parting thought, and that is, we've talked a lot about protecting our rights as minorities and Latinos to vote, and the demographics are there. Now we need to go one step further and exercise that right. So May 29th, while the court has not officially ordered that as the primary, that is the targeted date. So I think it's the next step, and we need to now exercise that. So thank you all. It's been an honor, and we will see you outside.